My name is Zeytuna Azasu. I work with the Africa Women's Development Fund, a consortium member of Amplify Change Program. I am a team member of Learning Monitoring and Evaluation Working Group, the organizer of these learning webinars, and I am your moderator for today's webinar. The main purpose of organizing these webinars is to share best practices and lessons from those implementing various projects. It is grantees-led and presentation are all made by grantees. We will have a presentation by Nerima from Kenya Legal Ethical Issues Network on HIV and AIDS, scaling on tracking progress in changing policies and laws, and she will introduce herself to you soon. Today's webinar is focused on policies and laws. It is in English and is recorded. The French translation will be done later. Both the English and French copies of the presentation will be made available on Amplify Change website. You can also find the previous webinars on the same website. These were the previous webinars that were done, so you can find copies on the website. The presentation will last approximately 30 minutes, and then we'll open the floor for questions and comments. You'll use the chat box that you'll find below on the right-hand side of the webinar page to write your questions or comments. I think now we give the floor to Nerima. Nerima, over to you, my dear.
All right. Good morning or good afternoon, everyone, or morning, depending on where you're from. I hope you're all doing well, and thank you so much for joining our webinar. So, my name is Nerima Akinyi. I am a lawyer and an advocate, and I work with the Kenya Legal and Ethical Issues Network on HIV and AIDS in Kenya. And today we're going to be discussing, I'm the program manager for the Sexual and Reproductive Health and Rights thematic area. And today we're going to be discussing how we track changes in policies and law. So I just wanted to begin by giving a brief introduction to my organization before I discuss what SRHR is. So Kellen is an independent civil society organization. We work in Kenya broadly on access to health for all. Our initial mandate was around HIV and AIDS, but we expanded that once the Constitution of Kenya changed in 2010 to focus on health-related issues broadly. So one of the thematic areas in which we work is sexual and reproductive health and rights, where I am focused. And the focus of that is really to push for enabling legal frameworks for the access of rights as they're encompassed in our constitution and international laws and regional normative frameworks. So we really, really do focus on creating enabling legal frameworks, and one of the things in doing so is ensuring that once you have laws in place, how do you make sure that these are being implemented, or that if you have bad laws in the books, what do you do to address them? So now, just to go back a step back, understanding SRHR is very important because sexual and reproductive health and rights, it's not one specific right that you speak to when you talk about SRHR. It's a broad framework of normative context because there are a lot of things that underpin what SRHR is, and it's not necessarily just reproductive rights or reproductive health. There are a lot of civil and political rights, the economic, social, and cultural rights that underpin what SRHR is, including the right to autonomy, the right to liberty, the right to life, freedom from torture and other forms of degrading treatment, the right to privacy, respect for family life, non-discrimination, and equality. So it's a broad conglomerate of rights that actually speak to what SRHR is, and being able to realize SRHR requires realizing all of these rights because they're interdependent and they're connected in a way that they must all be met for you to have your SRHR fully realized. Now, I just spoke about SRHR being a broad conglomerate of rights, but now let's speak about what an enabling legal environment would be. So you have to be able to define and fulfill all these rights, and you have to have a legal framework that guides such definition and fulfillment. So for instance, I can give an example of reproductive health or reproductive rights more clearly. The reproductive rights were defined most clearly by the ICPD Conference, International Conference on Population Development Conference in Cairo in 1994, which defined it as the right have to choose if and when to have children and the number of spacing of those children. So for you to be able to give content to this, right, you have to define it within each of your normative contexts. So if you have the right to choose if and when to have children, if is one thing. So you also have the right to decide not to have children, and what does that mean? And if you choose to have children, you have the right to decide when to have children and what does that mean. For instance, you might want to have children, but not at the time that you become pregnant. If, for instance, you're a teenager and you're still of school going age. So what policies do you have in place to ensure that if you do become pregnant and it's unintended, what mechanisms do you have to access services to either terminate the pregnancy or, if not, to prevent a pregnancy, such as contraceptive services, reproductive health information. So being able to define what this right means, what these rights mean, is quite important in every single normative framework. So basically, while you have an enabling legal framework, you should have an enabling legal framework. The law is quite important, but it cannot by itself singularly shift the reproductive health and rights discourse. You have to do a number of different things to be able to shift this in terms of social norms, behavioral change. There are a number of different interventions that need to happen, but this happen much better when there's an enabling framework to guide them. So the first step is, in discussing an enabling legal environment, you need to understand what your situation is. So this starts with a situational analysis. So for you to be able to track changes in laws and policies, you need to know what your baseline is. Where are you starting from? And this is normally a scoping exercise. The easiest way would be to check what laws do we have on this subject matter, and then where are the gaps based on the laws that we have. So you should be able to define two things. What is your current condition and what is your desired condition? Where are you now? Where do you want to go? So because SRHR is very broad, depending on your subject matter and subject area, it might be narrower. So for instance, if you work on maternal mortality or in reducing maternal mortality, your starting point would be, where are we with maternal mortality and what are the top causes of maternal mortality and how do they interact with law? So one good example would be access to safe and legal abortion or access to safe abortion. In many countries, abortion is restricted. And the restriction of access to abortion then means that you have more backdoor or more illegal abortions that are unsafe, that then leads to a rise in maternal mortality. So then your starting point would be, what are the laws on abortion in our country? What would we want the laws to look like in our country, based on how we want to reduce the numbers of maternal mortality as a result of unsafe abortion? So in your situation analysis, you're doing what we call a SWOT. So what are the strengths in your current legal and normative framework? What are the weaknesses? What are the opportunities? And what are your threats? So for instance, you can think about it this way. The strengths are, what are the good and positive laws that we have already existing? So if I can continue with the running example of abortion, if you have a termination of pregnancy act within your context, then that is a strength. Then you look at what are the weaknesses, whereby you look at the weaknesses both in the normative framework, but also in the law's ability to increase access. Because sometimes you can have good laws, but they don't necessarily impact on the lived realities of people within your country. So what are the weaknesses of that law and also that law's ability to shift the reality of the people in the country? And then the next area of discourse is, what are your available opportunities to change this? And we'll discuss that in more detail when we discuss processes. And then finally, what are the threats? And by threats, I mean, what is the likelihood that you might have opposition to any proposed changes that you have, and how can the situation worsen? You might push for an agenda that might make the situation worse. So being able to understand the landscape of rights discourse within your country is very important when you're pushing for law and policy change, because there might be a landscape that is not favorable for push of law and policy change. I could discuss one aspect in Kenya as an example is we recently had a case to decriminalize same-sex sex, not really same-sex relationships, but same-sex sex, because that's what's criminalized within our penal code. And there was a push to decriminalize same-sex sex because it increases stigma, it increases discrimination, it reduces it reduces access to services, and also is part of the reason why we have a high HIV epidemic. So then, because of this, we pushed this agenda through the courts. But because we were not quite aware of the threats that we had for our proposed changes, we were unable to read what kind of judgment we would get from the courts. And now we've gotten a judgment from our courts that has set us back a few years, set us back not a few years, a few decades when it comes to same-sex relationships. Because not only did the court say that there is no reason to remove the penal provision against same-sex sex, they went further to note that removing the provision would open this up to marriage, even though that was not part of the discussion. And that would be contrary to our constitution, which means for us to be able to push this any further in terms of reform, we need a lot of effort on our part as civil society. So now we get to the point. So now you've done your institutional analysis, you have done your SWOT, you know what your strengths are, what your weaknesses are, where are your opportunities for legislative and policy reform. So there are a number of possible processes that you can utilize. You can go through advocacy, litigation, or law reform. And this obviously differs depending on your context, because you might have a different context which might require different processes from you. But for the broad-based discussion would be the three possible forums. With advocacy, we mean you could either engage directly with Parliament if you have a National Assembly, or with the County Assembly, or with the Regional Assembly if you're from a federal system of state. You can engage with them directly in terms of pushing for law, or even more, you as a private member can introduce a bill to your Parliament if it's allowed in your system for it to be debated upon. You don't push how it's passed, but you can introduce a bill to your Parliament. Another option when it comes to advocacy is to create awareness around the issue, and then create awareness among the constituents of that area whereby you might need a shift. So back to my example on abortion. If you have high numbers of unsafe abortion within your country, like we do in Kenya, you can create awareness among the people within the country to push the discussion on unsafe abortion to their members of parliament, who will then be forced to have this discussion in Parliament and have a debate around it in Parliament. We can also consider litigation. So in some countries, you are allowed to challenge laws. And for the example of Kenya, we are allowed to challenge laws if they're not constitutional or if they fail to meet some process. In many constitutional democracies, laws are measured as against the constitution, which is the standard for which laws must meet. However, there are other opportunities to challenge laws, even though you don't have a constitution against which you can challenge them, which might also speak to the process under which laws were made, because some laws don't meet the correct process. A good example of this would be in Uganda, whereby the parliament was seeking to pass an anti-homosexuality bill, and it was challenged on the basis of the process under which it was passed, because it didn't meet the relevant quorum within parliament to pass the law, and they did that, it was passed. So then the law was struck down on the basis of failing to meet process. But basically what litigation does is it allows you to use the court as an avenue to develop the normative framework. So with the court, you're not limited just to existing laws. You can also look at practices. So let's say there's a practice within your country whereby an example would be, let's say doctors are refusing to provide health services to people because of their sexual orientation. So that is a practice problem that might not really stem from any law. If you challenge that in your court system, you might be able to get a positive judgment that says you cannot discriminate against somebody based on their sexual orientation and deny them health services. And then that would then be a policy decision coming from the court. And that can then be translated into policy by either the Ministry of Health or into law by the legislature. Finally, we have the process of law reform. Now, law reform is normally an ongoing process in many countries, depending on your framework. You can have a constitution that then pushes the need for law reform. But with us, we normally have a law reform committee, which continuously looks at laws and sees whether or not they're up to standard or if they're going within the direction of the country. And in that way, you're able to remove obsolete laws or problematic laws. So the law reform process is normally a fairly neutral process that can allow you to engage with a neutral body, if you have such a body in your country, on whether or not the law reform, on whether or not the laws that you have are appropriate for the country at the time that they're still being utilized. So with law reform, it's usually less contentious and less antagonistic, and you're more likely to push for it with law reform if you have a law reform body that is open, and if you have a standard against which to measure existing laws and practices. So when it comes to advocacy, you have to be clear that a lot of advocacy is around a movement and its activities, being able to look at what is happening within a broader movement. So any advocacy that you do has to consider what is happening around the entire movement. So we look at it as a whole movement thing. SRHR is one thing. So you have an entire movement on SRHR working on different aspects of SRHR. You can have somebody working on abortion, somebody else working on female genital mutilation, somebody else working on child marriages. All of them have SRHR components to them. So if you are asking for a law to be shifted, you have to be quite clear on what's happening within other factions of your movement and who's doing what and what they're doing, because you would not want to do something that is negatively impacts another movement. So a very good example would be adolescent sex. So it's a very huge problem in Kenya. It might be a huge problem in other parts of the continent, whereby you have adolescents that have sex with each other, and that act by itself is criminalized because adolescents cannot give consent. So the age of consent is the age of majority, which is 18. So no one under 18 can give consent to sex. So if you have two 16-year-olds having sex, that is a crime by both of them. So if I wanted to push for the recognition of adolescent sex, I actually have to work with movements that work with children, and especially children that have been exploited, such that if you're discussing lowering the age of consent, it's not being done in a vacuum. It's being done with children's rights groups. It's being done with groups that work on human trafficking. It's being done with groups that work to protect other members of the community, and it's being done with parents associations. There's a number of people that we need to engage in within the broader movement when you're pushing any one agenda. So if you do decide to push for something, work within a movement and work with different factions of the movement that might be affected by any decision. The next thing with litigation, once you have a SWOT analysis, you will be able to figure out a number of things. One is, what is your strategy? And is the matter ripe for a court? And by ripe, I mean, do you have the right parties at the time? Do you have the right issues? Do you have the right bench? And by bench, I mean judges. And is this the most effective tool? So if you consider ripeness, you have to know that if you're looking for strategic litigation, it's a very lengthy process. So having the right parties is important because they need to be part of the process for a very long time, and having the right issues and framing issues correctly is quite important. And having the right court is also very important, as our experience from Kenya is, if you don't have the right court in front of you, even if you framed your issue properly, they might just rule against you. And that takes you back a number of years. And also, is this the most effective tool? Because however you frame it, once you go to the court, judicial officers are not elected officials. So there might be a feeling that they're usurping the power of another body by making a pronouncement or a declaration. Therefore, what you want to do is make sure that you cannot do this through parliament, you cannot do this through other form of lobbying. So this is usually the last tool of resort. And then finally, with legal reform or law reform, is there any ongoing process? Can you latch onto it, and can you reach out to the Attorney General, who's normally the conduit for legal reform in a country? So now the last part, and this is normally a very important part, is auditing the implementation of laws and policies. And this is where most of us fail. So you do a lot of hard work to make sure that you have a law that is supportive to SRHR, that is supportive to specific SRHR issue, and then you pass the law and then you sit down. That is not sufficient, because when you conduct your situational analysis, it's not limited to saying we want better laws. It's usually we want to change a condition that will enable better access to something, or that will enable SRHR is being realized. So the law is just a tool to better realization of rights. Look in my example, I mentioned skilled birth attendants. So let's say you have high maternal mortality and you find from institutional analysis that it's because of limited access to skilled birth attendants. So if you pass a law that recognizes skilled birth attendants as including midwives, because you noted that in institutional analysis, a non-recognition of midwives is why you don't have as many people with training as skilled birth attendants that people have access to, because more women have access to midwives than they do to doctors and nurses. So now you advocate for changing the law to have midwives recognized as skilled birth attendants, and then you ensure that they have training to be skilled birth attendants, that they have access to health facilities, that there's an increase to antenatal care. So being able to implement the law would, being able to audit the implementation of the law, be able to say, we now have this many midwives recognized as skilled birth attendants. They are now able to access this level of training, and this many have access to training. And because of that, this many women can now access skilled birth attendants. So you have to be able to measure the impact of the law that has been passed on the condition you sought to change at the beginning. If there is no impact, there may have been a miscalculation by yourselves or your team when you started the process of legal reform or policy change. Because if there's no impact, if we go through the entire process of law reform and you see people are still dying in large numbers during childbirth, then maybe we miscalculated. So in this sense, your audit has to be multi-layered. One, firstly is the law being implemented? Because a lot of the times we pass laws, but we don't implement them. We don't put budget lines for them. We don't put things in place that will ensure that they're being implemented. That's the first thing. Is it being implemented? Secondly, is it being implemented fully and properly? It's one thing to implement, is another thing to implement fully and properly. And for you to be able to figure that out will be to determine what was our theory of change with this law, what was the purpose and objectives of this law, and be able to see, are we meeting those objectives? Is the law being financed? If it is being financed, are the finances being used properly? Is it reaching its intended beneficiaries, and have their lives improved? That is the end question. Have the lives of intended beneficiaries improved because of this law? And this really requires a number of different partners to be able to realize this. You have to have partners who understand the legal and policy framework, the legal and policy process. You also have to have partners that understand the budgeting process, and they may not be the same partners. You have to have partners that understand health systems and how they work and how they're influenced by legal policy. And they may not necessarily be within the same office or within the same team, but you have to work with many different people to be able to fully audit implementation of laws. So to conclude my presentation, and I have very little time left, you need a baseline. You can never start a process of advocating for any policy reform without understanding at base what you have available and what you need to change. And your baseline or institutional analysis is really informed by the work you do and the condition you're trying to shift. Secondly, in pushing for reform or enactment of laws and policies, you have to look at what work has already been done and what are the gaps. Because a lot of work is ongoing within many different contexts, but what are the gaps that you need to fill in through your advocacy or your litigation or your law reform process? And then finally, has this resulted in shifting the lives of women, girls, men, whoever within my community? That should be your eventual answer in auditing implementation. So thank you so much, and I'm now open to questions.
Thank you, Nerima. That was wonderful. So it's now open If you have any questions or comments, you can use the chat box and you can write them. Either Nerima or I read the questions and we'll try to provide responses to them. Meanwhile, while we are waiting for the questions and any comments, Nerima, if you have any other things you would like to add, we can run them parallel.
Okay. So, just to add, a lot of the presentation was based on a common law system of legal processes. However, it can be adopted for civil law system, but with modifications depending on how your parliament is set up, how your judiciary is set up, and the powers judiciary has. So I'm basing my presentation off of Kenya's judiciary now. However, Kenya's judiciary before 2010 could not question parliament and parliament's processes, which means before 2010, any law passed by parliament, which means before 2010, any law passed by parliament could only be questioned on the basis of process and not on meeting a particular standard. So the judiciary may not have been your tool or your eventual place to go if you needed a final declaration, because Parliament could overrule the judiciary at any point in time. So depending on how your system is set up, you may have to modify which tool is more efficient and effective for you.
Okay, I see some few people typing, but I think they are still typing. Yeah.
Okay, that's
Yeah.
fine.
So we can see one. I think Nerima, you can see it, right?
Yes, I can see the question.
Yeah.
So the question is, and I'll read it out. Did you
Yes.
have any experience in naming and shaming of people taking up the issue by government authorities or legal authorities? If yes, how did you deal with it? I am not very sure I understand that question. Um,
It's by Jos Thomas.
Jose,
Maybe
would you be
the
able
person
to
will provide.
expound
Yeah.
what you mean by taking up the issue by the government authorities or legal authorities? And of course, I'll get back to that question once you have given a little bit more detail.
Yeah. Yes, I think the person is typing now.
Yes.
Yeah. Okay, we have a number of people typing. Just hold on a bit. Okay.
Okay, so how can the SWOT analysis be used for policy change? Okay, thank you so much, Kuna Richard. So how the SWOT analysis can be used is it's a part of the process of determining what policy you need to change. Because it will be very difficult for you to push for policy change without understanding what the gaps are in your policies. So when you have the SWOT analysis, you're looking at a few things. And let me move back in my presentation so I can show you as I speak about it. The SWOT analysis will push you to do one thing. One, find out what is good within your existing policy framework. What are the strong points? What are the strengths that you have? Now, the next thing would be, what are the weaknesses? And the gaps can be within the law itself or can be in how the law is implemented. Because you might have a good law that is being badly implemented, or you might not have a law at all. So you have an entire gap. So now the opportunity section of your SWOT analysis will tell you what might be the best tool to utilize to push for policy change. So for instance, let's use a question of maternal mortality as a result of hemorrhage. So let's say the strengths are within your system is that you have skilled birth attendants, you have enough facilities, but the problem is the the problem is there are some communities that do not believe in accessing skilled birth attendants. So now the weakness is, despite having a good law or good policy around hemorrhage, around access to maternity care, you don't have it being implemented in many different communities. So now your opportunities here are around, you can work with the Ministry of Health to develop a policy around engaging specific communities and creating information and awareness around the need to access maternity care within facilities. Or you can decide, based on this, I will do direct advocacy within that community. And then finally, your threats would be who is likely to push back against my activities. So if I choose to do advocacy, who's likely to push back against my advocacy? So with our example, there might be within the community elders or chiefs or leaders who say a woman will not give birth in a hospital because strange things happen there. They will give birth at home because we have our traditional birth attendants. But the traditional birth attendants don't have the tools and facilities to ensure that if hemorrhaging occurs or if there are complications, they can manage it. So then you have to be able to identify who my threats are and how I can engage those threats to now address pushing my opportunity across. So pushing my advocacy either with the Ministry of Health or within the community itself. So this is your SWOT analysis and policy change. A policy isn't just always a law, it can be a practice or a decision within a government entity. So you're now working with the Ministry of Health, having identified this is what's good about the policy on managing on maternity care within this country. These are the weaknesses. It doesn't apply to this community because they don't believe in it. They don't believe in utilizing facilities. What is the opportunity to change it? Either
Nerima, we
yes.
missed the last sentence or the last one or two you said because we had a bit of a break. Could you
Okay.
go over it, please? Yeah.
So this is what your SWOT is going to do within my example of having a policy on ensuring maternity services are provided in a facility. So you say this is our policy, and we say that in our policy you have free and you have compulsory maternity care in a facility. That is good. The weakness is it doesn't apply in community X because they don't believe in utilizing facilities. The opportunities are to develop policies, to reform that policy to take into account the different needs of different communities and what you need to invest in. Because it's one thing to say we have a blanket policy, it's another thing to say this will not apply in community X, so we need to tailor it for community X. And then finally, your threats might be people within community X themselves that might push back against any policy reform or shift, that might want to come within the community and provide education and information around why it's good to use a facility. So that's how you can use your SWOT analysis. Now the next question is from Hira Baig. How policy level initiatives can be undertaken? So I am not sure I understand the question, but a policy level initiative, I would imagine you're talking about how do we shift a policy, right? So normally it depends on which arm of government you're dealing with. Because in most countries, you have the legislature or the parliament that passes laws, but then you have the cabinet secretaries or the ministries that can develop policies to put those laws into action. So when you're dealing with a policy, you're going directly to the ministry and saying, we need a policy to be able to make sure that this act is being realized. So if you say we have a law that says, and normally a law is written in very broad language. So we have a law that says everyone has a right to access reproductive health services. That's the law. You need a policy to break that down. What is a reproductive health service? That could include contraceptives. That will include maternity services. That will include ANC, post services. That might include access to safe and legal abortion. There are many different components on reproductive health services. So then you take the law and you go to the ministry and say, this is what the law says. These are the components of the law that we need to be able to have in place for us to actually realize reproductive health in this country. So how do we break down the different areas of reproductive health and then give them specific flesh? So now they are working directly with the ministry to develop policies. And that is an advocacy question. When you say, Minister, this is what we need to be able to ensure that if we have high teenage pregnancies in my country, if we have high teenage pregnancies in a particular area, this is what we need to have in place to ensure that we have less unintended pregnancies among young people. So that might require increasing access to information around contraceptives and increasing access to contraceptives. So that is how you can take for the policy initiative. The next one is, thank you for the great presentation. Could you please mention an example where you partnered with other organizations, members of the SHR movement, to bring about policy or law change? Okay, so I have a number of examples. So one example is around access to safe and legal abortion in Kenya. And this was because we have high numbers of unsafe abortion within Kenya. We have around 464,000 abortions annually, and around half of those are unsafe abortions. And about 13% of all maternal mortalities in Kenya are as a result of unsafe abortion. So we had, because of continuous advocacy among the SIHR movement, and this is across the board. So we had advocates who work on reproductive health and rights, advocates who work on health broadly, working together to push for the enactment of standards and guidelines for the management of maternal mortality as a result of unsafe abortion. So that was one aspect. We worked with the Ministry of Health, with the Ministry of Health, with other members in the movement, and also with medical practitioners. So both doctors and specialized attendants, as well as mid-level attendants, which would be nurses and clinical officers, in developing this policy. And that was adopted by the Ministry of Health in 2016. But then it was withdrawn in the same year under the guise that they didn't have enough consultations because religious leaders were not comfortable with it, which then took us to court. So we worked very hard to have the policy adopted, working with a lot of partners, including medical practitioners. Religious leaders as well were part of that conversation. Um, Other civil society organizations, educators, a number of partners. And now, following that, the policy was withdrawn and we went back to court. We went to court now, and not us, the people within the SIHR movement, guided by FIDA Kenya, the Federation of Women Lawyers, went to court to challenge the withdrawal of that policy. And within that case itself, again, you saw women's rights advocates, medical practitioners acting as key witnesses, the Nurses Association helping in terms of developing content, as well as community members who work within communities where they have high rates of unsafe abortion as part of the case driving that agenda. And in June of this year, the court found that the withdrawal of the policy was unlawful and that the policy needed to be reinstated to ensure that women and girls can access safe and legal abortion within the confines of Kenyan law. So that is one example. So we have an example based on what we did to get the policy in place, and then an example of what we did to ensure that the policy would be put back in the books once it was unlawfully withdrawn. So I can now thank you, Glory. I can go back. Jose, can you please explain your question a bit more in terms of government authorities or legal authorities? In terms of naming and shaming, so I will say within the context of Kenya, naming and shaming doesn't work very well because we have a very extensive culture of impunity. So you can name someone and shame them, but it won't really change what happens. I think one good way, especially if you have a country that is highly donor dependent, is to utilize development partners in the naming and shaming. Because the civil society, when you do it, they listen, they ignore, they move on with their lives. One example is earlier last year, the Ministry of Health, working with the Kenya Medical and Dentist Practitioners Board, banned marriage stops. So they banned marriage stops, and marriage stops is one of the largest providers of safe abortion services in Kenya, but also they provide maternity services broadly, especially for hard to reach communities. So maternity services, contraceptive services, so they banned them from providing any safe abortion services, including post-abortion care. Now, post-abortion care in Kenya is emergency treatment and is guaranteed as a right in our constitution. So you cannot remove post-abortion care in any way. So they banned them under the guise that Mysops is providing abortion on demand. Now, abortion in Kenya is only allowed under three circumstances: life of the mother, health of the mother, as emergency treatment, and if allowed by any other law, which is very vague depending on who passes the law and when. We don't have a specific abortion-driven law in Kenya yet. So now the Ministry of Health banned Maristop, pushed the dentist board to ban Maristops, which then happened. And then what then happened was, even though there was pressure from civil society, which there was extensive pressure, they were not budging up until somebody informed Bill and Melinda Gates Foundation what was happening. Because Marisops provides contraceptive services extensively. And the Bill and Melinda Gates Foundation funds a large majority of our foreign funding on contraceptive services. So then, basically, because of the push from Bill and Melinda Gates to see that we will pull our funding if you guys are not following your own laws, then the Ministry of Health backtracked its declaration to ban Maristops. And then the dentist board also reversed its decision on banning Maristops from providing these services. So usually, depending on the context of your country, with Kenya, there's high levels of impunity. It's very hard to shift government and legal authorities only based on civil society voices. But if you have partnerships with massive development partners who are giving funding to your country, you might be able to shift the discourse a bit more.
Okay, so
I hope I've answered your question.
Jose has added the first reaction of the government reaction is why you. Are you one of them? He added the
Okay,
also
so yeah,
added
that
that.
is okay. So that is true, especially for LGBTQI conversations, abortion conversations. It's always, are you an abortionist? Are you a gay person? Whenever you, or are you pushing a Western agenda? Those are some of the things that we normally have responses when we want to engage the state or when we want to engage government. So usually, what works is not really naming and shaming, but putting what works to address that is putting your discussion in context. So if you say this is based on a specific right within our constitution, it becomes a bit difficult for them to say, are you one of them? Because saying, no, this is the right. It's there in our constitution. They're trying to exercise this right. Another thing is to make sure you have, especially in advocacy, you have supportive communities. So the more support you have, you spread your risk a bit more. So it's not just Jose doing it, it's X number of community members want these services. X and Y number of community members are demanding for this. So if you engage with communities that you work with, if you give them the right information, if you get them engaged in the discourse, if they know why this is important, it's less a you question and more a we need this as a country question. So it's really important to spread the risk. It's really important to engage communities because at the end of the day, even as civil society, we have to edge out of this work. And we have to have communities that are able to have these discussions without us. So it's very important to work with the communities that we're pushing the agenda for to ensure that they're representing themselves and to ensure that their voices are being heard outside of just us. But it's very important also, as I mentioned, to frame your discussion on rights, not just on any behavior, just on rights, and say it's not about who I am, it's about what rights I am advocating for. This is your job as the government to make sure these rights are being made available. So anything around are you one of them is a diversionary tactic and a red herring, and you need to bring them back to topic.
So
Um,
yeah, Kabita, Fiona, and Godwin. There are three more questions
okay,
down there.
so Kabita's question is greetings, institutional analysis. It said that starting point of tracking changes in laws and policy through institutional analysis. Please clear it. Does it affect? Okay. Yes. So let me get back to this again. So why it's important to have a situational analysis is you cannot track without knowing what your baseline is. Because the entire hope is to track a change. If the laws and policies change, you need to be able to say, this is where I started from. Or if the condition you're looking to change changes, you need to be able to say that this is where I started from. So being able to understand where you start from is important to be able to track any eventual change. It's like a theory of change. What change are you trying to seek? And for you to be able to measure your change, you have to be able to have a starting point or a baseline. So situational analysis can do one of two things. Because I am assuming you don't work just on laws and policies, you work on laws and policies for a reason. When you do a situational analysis, it's showing you what the gaps are in law in addressing why you do your work. So I'm going to use teenage pregnancy as an example this time. If you work in a community where there are high levels of teenage pregnancy, you'll be able to do a situational analysis to tell you if there are gaps in access to contraceptives or gaps in access to information. That is why they're high levels. So is it access to contraceptives or access to information about sexuality and sexual health and how to engage in sex or not engage in sex? If you decide that it's a gap in access to information, then you have to look at what are the laws with regard to information to people under 18 who normally don't have the power to consent to accessing information by themselves. And if the issue now is because they can't consent to accessing reproductive health and rights information and it's not taught in schools, then your gap is you don't have access to information to young people within your policy framework. So that's your gap. Now, you will now then use your situational analysis to show you what your gap in policy is. Either you don't have a policy on young people, or if you do have a policy for young people, it doesn't include access to reproductive health information, which means there is no information in schools that will guide them.
Yeah.
And if you can show that, then you'll be able to figure out how to change that using the opportunities that you're going to show in your situational analysis. And then you'll be able to highlight the threats. So if
Okay.
you show, okay, let me move on to Fiona,
Yeah.
sorry.
Fiona asks that in advocacy and law reform, you might encounter conflicting positions within the movement,
Yes.
liberalizing laws versus expanding circumstances for legal abortion. Have you experienced any of such situations within movements, especially around abortion law reform? And how did you overcome that and ensure everyone is mobilized around the same agenda?
Okay, thank you, Fiona. That's a very good question. So that is very true. There are conflicting positions within movements, and usually it's a very difficult and tenuous thing to try and address. Currently within the movement in Kenya, the main issues are because on liberalizing abortion laws, the main issues are within our movement is because of how we have framed our discussions through and through. Abortion is always a public health issue, which means every time we're discussing abortion, we're not discussing from the point of autonomy, but not from the point of public health, which means then the discourse is always around expanding the circumstances as opposed to liberalizing the laws. Because it's not about autonomy, it's about how many women are dying, how can you reduce that? And you can reduce that by expanding the circumstances under which people can get an abortion. So this is a continuous tension that has been caused by our constitution, because our constitution is by itself quite restrictive on when abortion is permitted. So we're very limited in our entry point into the abortion discourse. And we haven't been able to agree as a movement, how do we expand our discussion? And now Kenya is getting to the point that as a movement, we are going to now consider going forward. We have discussed it as a public health issue. We need to get into the autonomy discussion and liberalize the laws altogether around the autonomy of women and girls to choose, and not as a public health crisis. So it is a very difficult thing. And the same problem was experienced within the LGBTQI movement, in that the court case wasn't agreed upon in terms of timing. There was a process of sequencing cases to reach to eventual decriminalization, but then the decriminalization case became before the movement by itself was ready to push it. So they were caught unawares because somebody took the case to court and they all had to respond and react. So reaching consensus as a movement is actually quite important. So you might feel like the movement is not moving as fast as you would like, but it's actually really important to get back to the movement and say, fine, why do we feel we can't go to liberalizing laws yet? And are these valid reasons as to why we can't get there? And if they're not valid reasons, then say, this is why we need to move. But it would be very dangerous to move on your own, because I've seen that backfiring quite remarkably if the movement is split. Because you might have the movement either just supporting because they have to, or not supporting at all, and you're not having as much advocacy as you would want around an issue. So it's these are important conversations to have within movements. They must be continually had, and you have to be able to understand if people are moving a bit slowly, why are they moving slowly? Because they might have a deeper understanding of context that we don't. But if they don't, we need to be able to advocate within the movement for why we have to move in a different direction and move faster. Godwin,
Yeah.
please can you share any strategy that would aid collaboration between a mainstream SRHR organization, stock members of sexual minority SRHR organization, member for policy reform, especially in country we're seeing. Okay. Hi, Godwin. Thank you so much. So I think a good strategy that would aid any kinds of organizations, any collaboration would be to look at the challenges towards SRHR as anti-rights and not and not issue specific. So normally what puts us in silos is thinking around our issues as very specific to us. I work on safe and legal abortion. However, the attacks on safe and legal abortion are really from the same people as they are for sexual minorities. And the attacks on safe and legal abortion are about controlling women. The attacks on sexual minorities are about controlling who is seen as a proper person within a society. So it's really the same types of attacks. It's an attack on autonomy, it's an attack on your right to choose, it's an attack on you on the basis of your gender or your orientation. So it's about equality. So being able to look at it as a broader rights issue and not a very narrow issue specific problem really aids in collaboration. And I think this is a very well timed question because in the current environment, we have a lot of attacks on specific issues based on a broad anti-rights agenda. And we don't have a movement addressing the anti-rights issue because it now attacks LGBTQI today, and then tomorrow they attack abortion, and then the next day they attack sexuality education. But we're not agreeing in context. We're not agreeing on how to address it as partners. And that's really stems from the issue that we are working on issues and not broad-based movement rights shifting agendas. And we need to reorganize around what are the rights that we want to have within our country and how do we want to push that. And as SRHR, broadly speaking, would capture everybody, including sexual minorities, including children accessing information. It would capture everybody. But then we work on very specific issues. So we have to break down the silos.
Okay.
Yeah, I hear Zaytuna humming, but
Yeah,
yes.
we are left. Yeah. Are you okay? Are you done?
Yes, I am done.
We have one request from Vivian on the French translation, just to
Okay.
assure that the French translation will be done later. For now, we have only the English presentation. We'll do the French translation, and both the English and the French copies will be on the website soon. Yeah. Yeah. Nerima, thank you
Yes.
very much for sharing your experience with us. It
Okay.
was insightful and lessons shared are useful. I don't see any more questions or comments. So I think that will bring us to the end of the today's webinar. Thank you to the Learning Monitoring and Evaluation Working Groups and the communication team for helping organizing in this webinar. And thank you all for attending and taking part in this discussion. And I wish you all a nice day.